So as I was saying, Schedule 1 is states and UTs, Schedule 2 is salaries, salaries of President, then of course governors, then presiding and deputy presiding officers. So the VP salary is mentioned indirectly because you know very well the VP does not get salary. The money he gets is on account of him being the chairperson, the presiding officer of Rajya Sabha. So the VP gets his salary not because he's a VP, but because he's a chairperson of Rajya Sabha. And that is why presiding and deputy presiding officers. Okay, then who else? Supreme Court, High Court, judges, and one more, CAG. That's it. Only these categories salaries are mentioned, so don't be confused. Not the chief election commissioner, not the chairman of UPSC, etc. Just these people. Clear? So this is for Schedule 2 salaries of these people. Then we have now, next is Schedule 3. And what is Schedule 3? Can you please tell me? Oath or affirmation. So if you are a religious person, believe in some magical being, you take an oath, or else you simply affirm. I solemnly affirm. Again, whose oaths are mentioned in Schedule 3? President? Okay, very good. Vice President? Very good. Neither President nor Vice President. President's oath is mentioned in a separate article called Article 60, and VP's oath is mentioned in a separate article called Article 69. Okay? Governor? Not governor also. Oh, PM, all the ministers. Why just PM? Every minister. So, oath for ministers. Ministers at the central level. Also the states. So, every minister's oath is mentioned here. Okay. Ministers take two types of oaths. Oath of office, oath of secrecy. Office and secrecy. One small point I'd like to make here is that, you know, for these oaths, what happens is there is the oath of office for the minister, in which there is a term, sovereignty and security of India. Okay. They also try to uphold the sovereignty and security of India. That part is actually added through an amendment. Clear? That small part is added later on. So you can just write like this: sovereignty via 16th Amendment Act 1963, the Sovereignty and Integrity of India, part 16th Amendment Act 1963. This was because, you know, we had the Indo-China issue, the debacle that we had to face and experience because of the Nehruvian policies of, you know, Hindi, Chini, Bhai Bhai, all that. Everybody is a friend. We win hearts by, we don't win wars, we win hearts. Sadly, we lost the war. We don't know whether we won the hearts or not. So, this. Then, coming out of ministers, who else then? Of course, we have all the legislators. Every legislator, that means MP, that means MLA, that also includes MLC. All these legislators, their oath is mentioned in the third schedule. Clear? Then what else? All the candidates. All candidates who are contesting election. So first up is ministers, second legislator, third candidates. All candidates who are contesting elections. For the Lok Sabha, Vidhan Sabha, Vidhan Parishad, their oath is mentioned here. Okay? Every candidate. And then of course, the Supreme Court, High Court judges, and lastly, CAG. Those two are common for both Schedule 1, 2 and 3. Let's not forget. That's it. Schedule 3 oath. This is the Schedule 3 oath and affirmation. Okay. Then next is Schedule 4. All done here? Now what is Schedule 4? Allocation of seats to Rajya Sabha. Okay. Allocation of seats to Rajya Sabha or Council of States. So every state different seats. Unlike in the case of USA, we have in USA, every state has same number of seats in their upper house, which is called what? Senate. Okay. Then next is Schedule 5. We'll discuss this in detail later on. But for now, Schedule 5, scheduled areas. In how many states? 10 states. Okay. In 10 states, not 4 states. Does your state have Schedule 5 area? Andhra Pradesh? Telangana? Both states have Schedule 5 areas. Okay. Scheduled area, though I'll discuss this point later on also, but scheduled, what is a scheduled area? Of course, the official definition is that any area declared by President as such is called a scheduled area. But what's the meaning of scheduled area? No, that's one effect. But what's the meaning? Oh, directly land purchase, so full land purchase interest. Schedule 5 area is an area which has 50%, more than 50% tribal population. Okay, any area which has preponderance of STs is called a scheduled area or can be declared as a scheduled area. That's one criteria. Some of you were mentioning about 4, that for Schedule 6, which is tribal areas. Again, we'll discuss this also in detail later on. So tribal areas in how many states? 4 states. Can you name the 4 states, please? Assam, Meghalaya, Tripura, and Mizoram. AMTM is what you remember, or AMGTMZ, because M can be Manipur also, don't be confused. These 4 states have Schedule 6 areas. Done? All okay so far? Great. Then we have Schedule 7. What is Schedule 7? Lists. We have 3 lists. The union list with 98 topics. Then the state list with 59 topics. And the concurrent list with 52 topics. Okay. Apart from it, we also have a concept of residuary powers, meaning powers which are not mentioned in any list are known as residuary powers. Okay. So union list, only center can make laws. State lists, normally states can make laws. This list, both can make laws, but center has overriding power. And then residuary powers, who makes laws here? Only center. Okay, Article 248, only center can make laws on residuary powers. Okay, things like cyber security, artificial intelligence, etc. Clear? Should we proceed now? Okay. Then we have Schedule 8. I think it's there on your first page. Schedule 8. Yes. So Schedule 8 is actually languages. Now couple of things to understand. If you want to modify this Schedule 8, how can that be modified? By Article 368, okay? We have to make a constitutional amendment to modify Schedule 8. So you can just write here itself, Article 368. This will help you understand that any modification can be done through Article 368. So to give you some examples, like say Odia, okay? This Odia, the spelling earlier was O-R-I-Y-A. We have modified the spelling, very simple. But for that also we had to make an amendment. So this was the 96th Amendment Act of the year 2011. So through the 96th Amendment Act, we have modified the spelling of Odia to make it O-D-I-A. Okay. Originally we had 14 languages. Now we have 22 languages. This means 8 additions have been done later on. UPSC has already asked a question on this topic. Okay. So we should know these additions. For example, Sindhi is the one which was added for the first time, or the first change, which was which was 21st Amendment Act 1967. Okay. Then 3 languages, you can see the 3 languages here, Nepali, Konkani and Manipuri. These 3 were added through the 71st Amendment Act 1992. So make sure you write like this. All these 3. Nepali, Konkani, Manipuri. 71st, 1992. 71st, and I am writing here 1992. Okay. And the last 4, Dogri, Santhali, Bodo, Maithili. This was also, these 4 were also added later on. 92nd Amendment Act 2003. So all these 4 92nd 2003. Okay. So all these changes have been made later on. So Dogri, Santhali, Bodo and what? Maithili. These 4 added later on. The previous question for UPSC was asked on Nepali, Konkani, Manipuri and all. So we can expect a question on these kind of topics. So while discussing this, just to also clarify, these official languages etc. are also mentioned under part 17 of our constitution. You can just mention somewhere part 17 dash languages, because we see some comparisons being done in questions as to which part contains what information, like part 5 is union, part 3 is fundamental rights. Similarly, part 17 dash languages. Okay. Just on a side you can mention somewhere part 17 languages. Done. Now there is a concept called classical language. This is not mentioned in the constitution firstly, so write in bracket, not mentioned in. I'll use this as a symbol for constitution, so don't be confused. So classical languages as an aspect is given by the central government. Clear? And why? Because recently, so originally the first language which was given the status of classical language was Tamil, then Sanskrit, Kannada, of course your language also, they don't panic, Telugu, Malayalam and Odia. Clear? But last year 5 more languages were added. So please make sure that you remember the names of these 5 languages that were added last year. Marathi, Pali, Prakrit, Assamese and Bengali. Okay, these 5 languages were added in this list of classical languages. Okay, I have also mentioned the criteria because we don't know this. UPSC has yet to ask a question on this. So if they ask you something on criteria, you can at least understand. Hear me out, very simple. The first criteria is that the text has to be very old, 1500 to 2000 years old. Second criteria is that it should have lot of ancient writings available which are passed down through generations. Lot of old books on that particular language should be available. Third is that the literature should be unique. This language should not be borrowed from some other language. Like Hindi is not a classical language because Sanskrit, it's borrowed from Sanskrit, right? And also that language should have evolved over time. Meaning how you use the classical form of language and what is the current use should be different. You know, if you remember English, Shakespeare's Victorian English, thou, hath it, all those crazy kind of words. We don't speak like that. That English is classical English. What we speak now is a different English. And what we Indians speak is a completely different English. Right? Eat no, go no. That kind of English. Okay? But that is also English, our own way of English. But the classical form of the language is different from its modern version and they may not directly be connected. Clear? 4 criteria, mug up the criteria also, and please remember this list, especially the 5 added last year. Okay. Also remember all these 4 languages which were added later, the 3 which were added later, and the 1 Sindhi. This means all the 8 additions including their amendment act needs to be remembered. Done? Okay. Then next is schedule 9. What is schedule 9? Schedule 9 means immunity from judicial review. Okay. So tomorrow we'll discuss more on this when we discuss fundamental rights. For now, this is sufficient. Immunity from judicial review. This means if you make any law and put it under schedule 9, it is immune from judicial review. Though we have made some modifications here, but that tomorrow. The IR Coelho case and all. Right now this information is sufficient. Are they clear? Then next schedule is schedule 10. What is schedule 10? Anti-defection law, ADL, right? Anti-defection law. So you will be disqualified on the ground of defection. Again, once we discuss parliament, then we'll discuss in detail anti-defection law also. Okay. Then comes schedule 11, or 2 of them together. Schedule 11. What is schedule 11? Any idea? There are some, it's like in a schedule 7. Schedule 7 is what? List of topics on which the center and states can make laws. Schedule 11 is like the same schedule 7. List of topics on which panchayats can be allowed to make laws. Okay. 29 functional items meant for panchayats. And lastly, we have schedule 12, which is municipalities. So 18 functional items for municipalities. Okay. Also quickly tell me, when were these 4 schedules added? Schedule 9, when was it added?
First.
Very good. This was added through the very first Amendment Act 1951. When was anti-defection law added? 51. Second, very good. 52nd Amendment Act 1985. Okay. When was this added, Panchayat? Okay, very good. 73rd Amendment Act 1992. And when was this added? 74th. Okay. Amazing audience. Very good. No, you have to keep on motivating people also, right? Fake motivation is very important. Done? Okay. So this brings us to an end of all our schedules. We hope we won't make any error if a question on schedule comes in the exam. That's our hope only. I mean, of course, all we can do is hope. Also, a topic where we have not seen questions recently, at least in the UPSC, but state PCS loves this topic, but we are here for UPSC. Nevertheless, should we proceed from here? All done? Okay. So this is the sources. So I know difficult to remember it. So what you can do is whenever you are reading polity, just read through this. Okay, and you will slowly and steadily have a hang of which areas or which topics have you borrowed from which country. So these are things we have borrowed from, we have drawn inspiration from UK. Parliamentary system that we follow is from UK. Single citizenship, rule of law, writs, writs, remember? Orders, that writ means what? Directive, order, which are issued by Supreme Court and High Courts to protect fundamental rights and other matters. Then first past the post that we follow in our parliamentary setup, whoever gets highest votes wins the election. Then the legislative process of passage of bills and all, it's all borrowed from UK. Cabinet system, the ministries, bicameralism, meaning two houses. Speaker's post, borrowed from UK. And the parliamentary privilege, remember, MPs do get this privilege benefit that they can speak anything in the house, any nonsense. No, outside the house also they speak nonsense only. But in the house, they have the protection that they can freely speak nonsense and no case can be filed against them. Clear? Then from Government of India Act, we have the federal scheme. See, Government of India Act was made by Britishers only. A lot of things are an overlap here. Judiciary, Governor's Office, PSCs, Public Service Commissions, the great bodies for which we are preparing, they have all been inspired by Government of India Act 1935. In fact, one-third of our, not one-third, people say two-thirds of our constitution is just the Government of India Act only, 1935, because it was already there in our country, our system. So we thought we'll just continue with it. Please remember this point and this point. These are two different points. Emergency provisions from Government of India Act, but suspension of fundamental rights during emergency. We'll discuss this later on, that your fundamental rights are suspended during emergency. Which rights can be suspended? Depending on the circumstance, it can either be Article 19 specifically, or movement to court for all the rights can be suspended. More on this later on. That has been borrowed from Weimar Republic. This is the Republic of Germany before the rise of Hitler. Because once Hitler came to power, he did not need any constitution. He was the constitution. Okay. And then in 1940s, Germany had a new constitution called Basic Law. So before that, it was a Weimar Republic. So emergency provisions, Government of India Act. But during emergency, there is one special feature that your fundamental rights can be suspended. That is borrowed from Weimar Republic. Difference. Then of course, from Canada, or as our Punjabis call it, Canada. Right? From Canada, we have federal setup, residuary power, appointment of governor. Please understand the same concept. Center appoints the governor in Canada also. So Canada also has a very similar kind of federal structure where center is very strong, states are relatively weak. So in India, we have this system that we call quasi-federal kind of system because center is very strong. Same thing in Canada. And this was in news recently, so becomes important. We'll cover this under judiciary, don't worry. But nevertheless, advisory jurisdiction of Supreme Court. Here itself, please mention Article 143. Very good. When the President seeks advice of the what? Supreme Court. Then comes South Africa. Two things. Procedure of amendment, that Article 368 thing. And also procedure of election of members of Rajya Sabha. Both of these things are borrowed from South Africa. So this is something that you have to remember. Then France, the war cry of the French Revolution, liberty, equality, fraternity, and the idea of republic. Then from Australia, concurrent list, joint sitting, freedom of trade and commerce. Okay. Then Ireland, DPSP, the method of election of president, nomination of members to Rajya Sabha. Like in our country, how many members are nominated to Rajya Sabha? 12. Which fields? Art, literature, science and social, not social science, social service. Okay. That's it. These 4 fields only. Don't create your own new fields. And at the state level also, some states have councils, right? How many states have councils? 6 states. So in the council also 1/6 members are nominated by governor. Which fields? Same 4 fields, 1 extra field. Tell me. Very good. Cooperative movements. Okay. 5 fields: science, art, literature, social service, and cooperative movements. Anyway, that later on. Then President's power to send messages to Parliament. This is Article 86 that we have borrowed from, you can write the clause also, Ireland. Then Soviet Union, duties, which we borrowed later on, and ideas of socialism, both inspired from Soviet Union, USSR. Then from USA, all these great things like fundamental rights, judicial review, post of VP, impeachment of president, removal of Supreme Court, High Court judges, independence of judiciary, and even due process. Since 1978, we'll discuss that tomorrow, fundamental rights. But since 1978, we have something called due process. Can you tell me the judgment? Which judgment was that? Which article has due process of law? 21. Okay. 2 things: procedure established by law and due process of law. It comes from Menka Gandhi judgment. Then from Japan, we have procedure established by law. This is mentioned in your article 21. You know article 21? The most important article. Right to life. If we are not alive, then what is the point of other rights? This right is more important. That's it. So go through the list some number of times and you can easily remember it. Clear? They might ask a match the following, etc. You know, UPSC can stoop to any low level to ask questions nowadays. Okay. Now let's come to preamble. Any informed aspirant would remember the preamble. I hope you also remember the preamble. No? You should. Very simple. You know, like how you remember your mantra and shloka and religious texts. When your parents force you to read it every day. And now you remember it. Similarly, next 5-10 days, just get up in the morning, go through the preamble, and after the 10th day, you will find this magical thing happen that you remember the preamble on its own. So just scroll to less reels and read the preamble. 1 reel, 1 minute, reading the preamble also 1 minute. That's it. So we the people of India, having solemnly resolved to constitute India into a sovereign socialist secular democratic republic and to secure to all its citizens justice, liberty, equality, fraternity, then also ensuring the unity and the integrity of the nation. And we have adopted this on the 26th day of the November 1949. This 26th day, what is this date called? This is the Constitution Day. Recently we celebrated it where all the aspirants posted status to impress other aspirants that how sincere you are of your preparation. No, it's not important to prepare, it's important to appear that you are preparing. Yeah, because parental pressure is also there. Until you are preparing, people will respect you. That what if you clear the exam and become an officer? So that's Constitution Day. Also, please remember, just here you can mention, so date of adopting the Constitution is 26th of November. Date of commencement, meaning when it began, 26th January 1950. Okay. So that point is different. Commencement is on 26th January 1950. Okay. Done. There are some things highlighted in color. I think. So tomorrow we'll have the handout in this format only. I think this fellow acted too over smart, and he just, the printout guy, he was dying to show his skills, and he showed his skills by formatting the entire structure. Okay, so just underline there itself all the words that we have underlined here in that notes only. So underline socialist, secular, and below that integrity. Okay, which means that these three words were added later on, later modifications. Should we proceed? So very quickly, let's go through the purpose of preamble. Please remember 3 important points. The nature of Indian state. So preamble tells us the nature of Indian state. Nature of Indian state. So India is a sovereign, socialist, secular, democratic republic. Then what are the ideals of our political system? That is justice, liberty, equality, and fraternity. And the sources. So what is the source of our rule book? We. Because if you read, we the people of India give to ourselves this constitution. So we have given this book to ourselves. Now you might say I was not born then. It does not matter. We have all given it to ourselves. It's forced completely on us. Whether you like it or not, you have to respect it. Like the relatives who come to your house, you have to. Okay. Then some very important points. Number 1, preamble defines objectives of the constitution. What is it that this book tells us about? Second, it's an integral part. Integral part meaning a part which cannot be removed, can't be taken away from the constitution. Clear? Very famous LIC case and the Keshav and Bharati case where Supreme Court said that the preamble is an integral part of our constitution. Clear? So you can't remove it. Then it is not, then it contains basic structure. Okay, things like socialist, secular and all are all part of basic structure. Again, Keshav and Bharati judgment, this also. When was this judgment? Keshav and Bharati? 1973. Very famous LIC case of 95, where this word integral was used. Okay. Preamble contains basic structure. Okay. Preamble is a part of the constitution. Every part is amendable, including preamble. So preamble is also amendable, except of course the basic structure. We can also amend the preamble. But this point is very, very important to remember. Preamble is not a source of power. Okay? To just briefly help you understand this point. On its own, preamble has no legal effect. Meaning, the words you see in the preamble, you can't go and claim them in the court. That equality of status, I want same status as Mahesh Babu. You can't claim all that. Okay. So, what is not mentioned in the constitution can't be claimed by preamble. Then what's the point? The point is preamble can be used with other provisions of the constitution to get a better understanding of the constitution. So on its own, no legal effect. It has to be read with other provisions of the constitution. If you have space there, please mention no legal effect independently. No legal effect independently. In bracket, must be read with other parts. must be read with other parts. Are you clear, everyone? No doubt? Should we proceed? Okay. Now we'll quickly go through the meanings, because we have seen sometime UPSC has asked questions on these keywords or the preamble. So first is sovereign. What is meant by sovereign? That no external power can dictate the government of India. We are free from any kind of external influence. That's sovereign. Then democratic, meaning government derives authority from people. Okay. What we follow is something called indirect democracy, representative kind of democracy, because we don't directly govern. We elect people based on them based on them impressing us. We go and cast our vote and then choose them, and then they will go and govern. Okay, make laws for us in the parliament. Clear? So government derives authority from the people. And what we have in India is indirect democracy. We can also have a direct form of democracy. Some countries do have direct form of democracy. This nuisance is created in country with lesser population. Sorry? Switzerland. Yes. Of course. Switzerland. In some aspects, for example, if you want to amend the constitution or you want to bring a bill, if 50,000 people sign, then that particular petition can become a bill also. In our country, we don't have all this nuisance. We have too many people, right? 50,000 people in our country, they are standing somewhere watching a JCB. So that's a very small number for us. Are we clear? And also, these are very difficult things, because in foreign countries, you have to sign and all. In India, who will verify the signature? Because in our country, right from childhood, every child learns the first thing, forging the sign of parents. So we have that skill set also. No? We can't really rely on this aspect. So we don't have it. Direct or indirect. Indirect, you have things like initiative. Initiative when you initiate proposals for legislation. Then what else? Any idea? Referendum first, when we can vote on bills. Then plebiscite, where we can vote on important matters. And one more, recall. What is meant by recall? Calling back an elected representative before end of tenure. Normally tenure is 5 years. We can vote for them, we can't call them back in between. But if we have recall, that will be amazing to call them back, right? No, we can't have recall, it's not practically possible. So democracy is something we know. And let's not forget the words of Abraham Lincoln. For the people, of the people, by the people. And you know the real meaning of it. It fars the people, it offs the people, and it buys the people. But we won't follow this. We'll follow this one. Far off and by the people. Okay, then comes the word republic. So what is the meaning of republic? We have drawn inspiration from France. Republic means your head of state is elected. For example, in our country, we have the head of state as president. Is he elected? No, he's elected. Indirectly, but elected. So president is elected indirectly or directly, it does not matter. The opposite of republic is what? Monarchy, where head of state is not elected. So the opposite would be monarchy. Elected head of state. Now, couple of more things to understand. Republic also means, you can just write two important points there. Number one, public posts is equal to open to all. Public posts open to all. Done? And second point, please write, sovereign power lies in the hands of people. Sovereign power lies in the hands of people. Okay, this is the meaning of republic apart from elected head of state. Then the other words, justice, fair and moral treatment of all means justice. We have social justice, economic justice and political justice. Then we have liberty. Liberty has two meanings. Absence of restraint, meaning no limitations. This is a negative meaning of liberty. We don't use this meaning anymore because it's not possible not to have restraint. Okay? What we use is the more positive meaning of liberty, providing opportunities for development. So if you get a question on explaining the meaning of liberty, please use this meaning. So liberty from, liberty to, liberty from restraint, liberty to develop oneself fully, providing opportunities for development. Clear? So if you have to choose, you will always choose the positive meaning of liberty in your answer. Clear? If both options are available. All okay? Meaning of liberty. Then equality. Absence of special privilege. Very simple. And lastly, fraternity, the sense and feeling of brotherhood. This is there to ensure unity in the country. Everybody feels like, not literally brothers and sisters. Don't worry. Don't panic at all. What is this happening? It simply means a sense of unity prevails in the country. Okay? Sense of brotherhood. Then three words which were added later on were socialism, secularism and integrity. So please remember the additions also. Which three words? Meaning we know very well. What is socialism? Social ownership of resources, meaning state control over resources. That's socialism. What is secularism? Principled intervention, meaning the state can interfere in religion. That's the key. So normally we start by saying that secularism means that we are free to practice our religion. That is there in various countries. Indian secularism is unique because of this concept called principled intervention. You can also find the word principled distance. What does this mean? This means that the state keeps safe distance from religion. But if the state feels that your religion is doing some drama, it violates public order, health, morality, etc., the state can interfere in religion. Are you clear? This is mentioned in Article 25 also. State can interfere to provide for what? Provide for social welfare and reform. Just mention this phrase. Social welfare and reform. For these two reasons, the state can interfere in your what? Religion. And that is why we don't really have that perfect strict separation. Like in the Western countries, there is strict separation. We don't have that. Here, state will interfere. Tomorrow I'll also show you the Article 25 where that phrase is mentioned. Okay. And then integrity, putting an end to the separatist tendencies in the country. So if any party, any person has an agenda to separate break away a small part of the country, like some people in Delhi were protesting that let's stifle the chicken neck and separate northeastern part. So all these are violating the constitution. Okay, these were educated people from big universities called JNU and all, but they have not read the books properly, or else they would not be protesting like this. Okay, so sadly that's the harsh reality. So this was all the keywords of preamble. Okay, please remember the meanings. We have seen on multiple occasions questions being asked from liberty, etc. in our prelims exam. Next is the very first part, that is union and its territory, part 1. We have 4 articles, 1 to 4. So first things first, this is the provision. We should all know as informed aspirants what is the first article, because to impress others also, this is important. So India, that is Bharat, shall be a union of states. So we start by a confusion only. What to call India? India, Bharat, let's call both. And we have called it both. So don't worry, Bharat is also correct. Last year when Bharat was used in some place, Congress became very offended, right? Because Rahul Baba did not know how to pronounce Bharat. Maybe you're right, I don't know what was the problem. But Bharat word is mentioned here, no problem. Both can be used. Now, important point to note is that it's a union of states. This phrase has a meaning. Why do we use the word union? Because no state has a right to secede, meaning move out of India. It's not possible. That is why we call India as an indestructible union. Okay, so we call India as an indestructible union. Okay, now comes one more aspect. It is not a result of a contract between formerly independent nations. So there are two ways to form a country. One is coming together federation, and the other is holding together federation. USA is an example of coming together, meaning formerly independent countries, they came together to form this country called United States of America. But India always existed, right? So it is a holding together federation. So always remember that we have this aspect called holding together, not a coming together. Okay, this is there in your NCERT also. Holding together federation. Done so far? Should we proceed? Okay. Now the important part of part 1. So what is part 1? Let's not forget this also. Part 1 is union and its territory. Now see, the states and the territories thereof shall be as specified in which schedule? First schedule. Names of all the states and UTs. Now comes the important part. This is Article 3. Okay, this is Article 3. Article 3 talks about reorganization. How can we internally change the boundaries of the states, their names, etc. Let's just read here. Formation of new states and alteration of areas. Do you have that? Yes? Okay, great then. So formation of new states and alteration of areas, boundaries or names of existing states. So underline this part. Parliament may by law. What is meant by law? Simple majority. This phrase by law means simple majority. Anytime you find the phrase by law in the constitution, it refers to what kind of majority? Simple majority. What is meant by simple majority? More than 50% present and voting. Okay, great. Okay. Done? So we can form new state, increase area of any state, diminish the area of any state, alter the boundaries, alter the names of also of any state. Nothing is fixed. So in 2014, a huge setback for Andhra people, right, and much to the happiness of Telangana people, the state was bifurcated and we had Andhra Pradesh and Telangana, with the pride of Andhra Pradesh, Hyderabad going to, with a heavy heart, Telangana. No, it is inside Telangana, what can you do? Don't cry, it's okay. So now comes a question that this requires parliament by law, simple majority. But there are some conditions for these bills. First condition, always remember, if you want to introduce such a bill which is called a reorganization bill, then such bills require prior permission of President. Important condition. Okay. Number 2, once this bill is brought, it will be sent to the state also. That Andhra Pradesh, are you satisfied? Should we bifurcate? If Andhra Pradesh says no, please don't, it does not really matter. The center will bifurcate if it wants to. It is sent to the assembly of the state to give opinion, which is not binding. So states have no role to play in this. They just told, like our parents tell us that we have decided for you this career, and you say, "Yeah, okay, no problem." Okay. Despite hating maths, you have to take maths. Same thing. Like some of you sitting here, no interest in UPSC, but still parents have decided UPSC means now UPSC, few years. Same thing. This also means that internal boundaries can be modified very easily. Yes or no? By law, and states have no control, which also tells us that India is an indestructible union of destructible states. So the second part of this phrase comes from which article? Article 3. First part of the phrase comes from which article? Article 1. This is a classic feature of federal kind of nations, unitary kind of nations, where center is very strong. If you look at any clear federal country like say Australia or USA, you will find that in those countries, second part does not exist. Why? Because in those countries, states' permission is mandatory to change names, bifurcate them, create new states, etc. In India, it's not mandatory. Are you clear? One small point. These 2 points, this special kind of situation, this special condition that is required for such bills is not applicable to UTs. Draw like this, you will understand. Why? UT is a part of center only. So if I today want to change the name of a UT, I don't need their permission. I don't need to send a bill there, not required. Okay. For UTs, no such prior permission is required. For example, we had changed the name of a UT around 20 years back. Pondicherry was changed to Puducherry in 2006. Or in 2019, we merged 2 UTs. Dadra and Nagar Haveli and Daman and Diu were merged because of administrative ease. So there also this condition was not required. Okay. Are you clear? It is only meant for states. One small point to understand, this is only meant for domestic reorganization, not for giving up land to a foreign country. For that we need Article 368. Just below this put a star mark and write like this. Article 3 domestic reorganization, and below that to cede territory, meaning to give up land, we need what? Article 368. This is what was Supreme Court's advice in the Berubari Union case of 1960. Also, just to clarify, Berubari Union is not actually a judgment. It is a presidential reference. Article 143, advisory jurisdiction. So government sought the opinion of Supreme Court that if we want to give Berubari Union Thana number 12 to East Pakistan, then what can be done? And that was the Supreme Court's observation. To cede, meaning give up, CEDE. Done? That's it. So always remember, now see, we can always go and look at all the list of when the states were formed, etc. Here, mug up all that information. That might not be required. Just a simple funda that you should remember. There is only one state in the country which has been formed through constitutional amendment. That is Sikkim. Because Sikkim joined us later on. All other states are formed through a simple majority. Are we clear? So all states are formed through Article 3 except Sikkim. Sikkim is the only exception Sikkim through the use of Article 368, 35th and 36th Amendment Act of 1975. All other states, Article 3, which means what?
Sir, Goa.
Goa, Pondicherry, yes, Goa and Pondicherry were also added like this only. The formation of states happened through a law, but the addition happened through the amendment, right? But the state formation came through Article 3. But for them, the addition happened through the Constitutional Amendment, and also state formation came through amendment. That's a point of difference, slight modified difference is that initially Sikkim did not join India completely, okay? They only partially joined India. They were called an associate state, okay? So firstly, we had an article called Article 2 capital A. This is still there if you see, they have removed it now. And also one schedule was added called Schedule 10. That was meant for Sikkim, okay? But after 1 year, Sikkim became a full-fledged state of India. So even the statehood status for them comes through amendment only. And these two were then what? Repealed. That is why we had 8 schedules. 9th was formed in 51. Again, Schedule 10 was formed. We repealed this 10th schedule. We went back to 9 schedules. And then in 1985, anti-defection law, again Schedule 10. So we have had 2 Schedule 10 so far. One was for Sikkim, the other which we have right now, that is for anti-defection law. Okay. So that was there with respect to these states. Okay. So that's it. Articles 1 to 4 are all done. Just remember Article 3 and this condition. Very important to remember this condition. And yes, in case you have some thing to understand, maybe things like Goa, Daman and Diu, and even Puducherry, all these were incorporated into the country through amendments, Article 368. But then the provisions have been controlled by Article 3. Rest all other states, say Nagaland, right, Tripura, every other state has been formed through, including your state, Telangana, in 2000 states like Uttarakhand, Jharkhand, go back to Haryana, all these states formed through Article 3, simple majority. Okay. Should we proceed now? All done? Now let's come to part 2, which is citizenship. So first thing is that citizenship is under which list? Can you please tell me? What do you feel? There are 3 lists, right? So it is under the union list. So part 2, the articles here are not important, so don't worry on the articles, but citizenship laws are made by, since it's a union list subject, entry number 17, only Parliament by law can decide on citizenship matters. Clear? Parliament by law, meaning simple majority. So we have a law, and that law is called Citizenship Act 1955. That's the major law which has been passed, which gives us various ways to acquire or even lose citizenship. Clear? So there are right now 5 ways to acquire citizenship. One is by birth. This is for people born in India. But this is also only for 1987. All people born after 87, it depends on your parents. Now you don't get citizenship by birth. Even if you're born in India, you are given Indian citizenship because your parents are Indian citizens. Are they clear? So by birth till 1987, and then after based on parents. Just remember this point, it is sufficient. We have not seen a single question on dates, etc. That which date and all. The UPSC has not asked a question on this ever. Then second is by descent. This is for people who are born outside the country. If let's say you tomorrow become an IFS officer and go to a foreign country or posted in some foreign location like Pakistan, okay, like New York, Geneva, happy. So there, and you get married, you trap some foreigner, you fall in love with some foreigner and then you get married. You have kids outside. Now they are born outside the country. How do they get citizenship? If you want them to get Indian citizenship, by descent. Okay. So this is for born outside India, and this is also based on parents. So these two are meant for people who are born to Indian parents, depending on where you are born. Then we have two more ways. This is meant for foreigners, registration and naturalization. So this is not meant for people born to Indian parents. This is meant for, or should I say, aliens? Yes? Aliens means foreigners, not the alien jadoo, foreigners. Okay. Registration is meant for whom? Association with Indian citizen. For example, through ethnicity, maybe your great grandparents were Indian citizens, or through matrimony, marriage. Okay, it is possible that you are sitting here and some foreigner comes to India and he or she is roaming around in Hyderabad and falls in love with you. It's possible, don't lose hope and all. And if they marry you and then they apply for citizenship, then they can get citizenship under registration. For example, Sonia Gandhi. Sonia Gandhi, a foreigner, married an Indian citizen. Later on, she became an Indian citizen. Okay, not immediately. After 15 years, she applied for it. She was thinking what to do and then she applied for it. Okay. So here, there is a condition of living in India for 7 years. This means you can only apply for registration after 7 years. So if you marry an Indian, suffer for 7 years first, and then you become eligible to apply. But naturalization is for complete foreigner. This fellow, no association with Indian citizen at all. So maybe some foreigner comes to India with his family and all, and they like India, great culture, great food, okay. They suffer from all possible diseases, also build immunity and all. Now they are happy. Then they can apply for citizenship under naturalization. Are you clear? Now, of course, people who apply under naturalization, they have extra condition. They have to take an oath of allegiance, loyalty towards India. That's just a fake oath, right? You have to take an oath, that's it. Don't take it too seriously. Just read the oath. For naturalization, there is one more condition. I hope you're aware. You have to also stay in India for 12 out of last 15 years. So I'll quickly draw this timeline for you to understand. So what year is this? 2025 end, right? Okay, let's call it 2025. Then 2024. So last 1 year, they should be staying in India continuously. And the previous 14 years, that is from 2010, in this entire period, they should stay for any 11 years. The total becomes how much? 11 plus 1, you can use a calculator, very simple. How much? 12 years. Okay. Time for photo session. Please look serious. Pose. Okay, writing very sincerely. Done. So this condition is important. This is only meant for naturalization. 12 years you have to stay in India. You can't just say I like India music is nice, food is nice. Stay for 12 years, breathe the same air, go to Delhi, survive, then come and then we'll see whether you can be an Indian or not. Okay. Then we have the last one, incorporation of territory. Very simple. There is only one small catch here. So if India occupies some land, all the people there may become Indian citizens. It is not automatic. It depends on notification by central government. Just mention this here. After notification by Government of India. So it is possible that you go and occupy Pakistan today, but who would want Pakistani citizens to become Indian citizens? Of course not. They are dangerous, crazy people. So we might not make them Indian citizens. So in that situation, those people will become stateless. Okay? Because they are not what? Indian citizens. So this depends on notification by Government of India. Okay? Done? So this is how you acquire citizenship, 5 ways: birth, descent, registration, naturalization and incorporation of territory. Now, loss. How do we lose the Indian citizenship? So these two things, by renunciation and by termination, this happens at your own will. I mean, they're making me laugh, sir. I'm just trying to. Okay, please continue. By renunciation and termination. One thing, this is a point where a question was asked in the exam, deprivation. So what happens in deprivation is that in the first two cases, like say for example, renunciation and termination, you give up the Indian citizenship, right? If let's say you join some other country's citizenship, you take Pakistan citizenship today, Indian citizenship is taken away automatically without informing you. Or you give up Indian citizenship on your own, you renounce it. Okay? So renounce is to give up. And termination is when you take another country's citizenship. So the moment you take any other country's citizenship, you automatically lose the Indian citizenship. We don't allow for dual citizenship nonsense. Okay. Deprivation done by Government of India. By Government of India. And always remember, deprivation can only be done for these two, registration and naturalization. You can write somewhere, registration and naturalization. This means those people who have obtained citizenship through these two processes, only their citizenship can be taken away. For us, all of us, hopefully we are all citizens because of birth. There is no provision right now in the country, no law which can deprive us of our citizenship. Nothing exists. Are we clear? So we don't know, you can do anything you want. They might jail you and all, but they will not take away your citizenship. There is no law for that. The law is only meant for these two, foreigners. Okay? That's it. So this is with respect to our citizenship provisions, renunciation, termination and what? Deprivation. Clear? Okay. That's it. So if you have to revise citizenship, focus on this part, not the constitutional provisions, because they are only meant till 1950. That's it. Who was a citizen of India in 1950? That's it. Not beyond that. Beyond that, we have a law called Citizenship Act 1955. Done? One small topic under citizenship needs to also be covered, and that topic is this. The CAA 2019. What is the CAA 2019? Oh, very good. Full form, not the full form, the provisions. So first provision is that illegal migrants who came into India from 3 countries, Afghanistan, Bangladesh and Pakistan, before 31st December 2014, and they belong to which religions? These 6 religions: Hindu, Sikh, Buddhist, Jain, Parsi or Christian communities. Now, this CAA does not give anybody any citizenship. It only says that these people will not be illegal migrants. Okay? So in our country, illegal migrants cannot apply for citizenship. Only legal migrants can apply for citizenship. So the moment you are no longer an illegal migrant, you become what? A legal migrant. So now they become eligible to apply for citizenship. This law does not give anybody citizenship. It only makes some people what? Eligible for citizenship. Are you clear? That's a point to note. They might trap you in a MCQ. And also, we saw these are all foreigners, right? Foreigners coming to India with no association to India. They get it under which category? Naturalization. How many years do you have to stay in India? 11 plus 1. The number of years of residency has been relaxed from 11 to 5. So for these people, the total would be 5 plus 1. This 1 remains the same continuously for 1 year. But before that 14 years, any 11 years. This 11 for them has been reduced to 5. That's a point of difference. Okay, so 6 years. And also OCI card cancellation can happen. There is this thing called OCI card, Overseas Citizen of India. OCIs are not Indian citizens. They are foreigners. Okay, who have been given a card called OCI card, which is nothing but a benefit of unlimited visa in the country. You can purchase land in India, etc. So your card can be cancelled if you break some law in the country. Clear? Because some people we have seen, they come to India and they take part in protests also. Foreigners come to India and take part in anti-India protest. That's the beauty of our country. So there the government has made this regulation now that if you break any law, then we will cancel your OCI card. Now a small point. This benefit will be extended to all these people who are living anywhere in the country, except in certain parts. Exceptions. Exception is that the CAA 2019 is not applicable to certain areas. Okay? This means if you are a Pakistani, you came running from Pakistan, okay, you entered say of course through Punjab, no problem, you stayed there, you will get the citizenship. You kept running, you came to UP, you can still apply under Citizenship Amendment Act. You keep running, you go to Bihar, you can still apply. But if you keep running more and you go to Assam, who asked you to run so much? Then you are not eligible for any benefit here. You are still an illegal migrant. So the exception number 1 is for all those people who are in Schedule 6 areas. That means the states of Assam, Meghalaya, Mizoram and Tripura. In these 4 states, those areas called autonomous districts, if you are there, you are still called an illegal migrant. No benefit for you. Are you clear? Is this point okay? One more exception is, yes, inner line permit, ILP. If you are somebody who was staying in inner line permit areas, so there are certain states which have the concept of inner line permit. Britishers made this concept in 1873. So you have states like Arunachal. When this law was made, AP is not Andhra Pradesh, it's Arunachal Pradesh. Okay. When this law was made in 1873, that area Arunachal was under inner line permit, excluded areas. outsiders could not go without permission. Even now, you can't go to Arunachal Pradesh without permission. So online you can apply for the permit, the pass. It's a monthly pass or an annual pass depending on which category tourist you are. Very cheap, 200-300 rupees only. You can apply for it. So states like Andhra Pradesh, then of course Nagaland. From the time Nagaland was formed in 1963, it has been a part of inner line permit. Then Mizoram, again from the time Mizoram was born in 1972 as a state, it has been a part of inner line permit. And one recently, which state is that? Manipur. Recently in 2020, Manipur was also added, and Meghalaya has been demanding for this status. Just few days back also again they had demanded that we want to be a part of inner line permit because this can restrict outside entry freely. Okay. So if you are an illegal migrant in these states coming from Pakistan, Bangladesh, etc., you will still be an illegal migrant. This benefit of CAA is not available to you. Are you clear? So please remember the names of these 4 states also. That's about it for citizenship provisions. Should we proceed? All done? Okay. Then a very simple topic, which is amendment to the Constitution. Please remember the part. Which part is this? Part 20, 1 Article 368. Part 20 is the amendment procedure. So you can see very well that Parliament may, in the exercise of its constituent power, amend by way of underline, addition, variation or repeal. Meaning they can add anything, they can remove anything, they can change anything and they can remove anything. Repeal means to remove any provision of this constitution in accordance with the procedure. So I'll discuss the procedure. Firstly, the voting. It's a combination voting that is required, special majority. 2/3 members present and voting, more than 50% total strength of the house. This is required. Okay. However, if you want to modify the federal features, then one extra step is required. That extra step is that you have to send the bill to all the states. The moment half of the states approve it with a simple majority, the moment half the states approve it, the bill is passed. Remaining half may approve, may not approve. That's of no concern to us. And let's say, how many states do we have right now? And we are talking about only states, not UTs. So we have 28 states, meaning half means 14. Not less than 50% means 50% or more. Okay, so 14 states. So 14 states, the moment the 14th state approves it, the amendment is made. So there is no time frame. I mean, some other countries like USA, there is a time frame that 3/4 states have to approve it within 7 years only. Here, there is no time frame. Are you clear? But the point is, what the hell is this federal structure? That's a big question. Yes or no? What is federal structure? So we have examples of federal structure. This is all mentioned in your constitution itself, same article 368. Election of president and its manner. So article 54, 55, the electoral college of president, all these things are covered under this. If you want to modify the voting pattern of president's election, then that requires states approval also. If you want to modify the limit, the extent of executive power of union and states, that also requires what? Special majority with states' consent. Or Supreme Court and High Courts, if you want to lower or take away their power, that requires special majority plus states' consent. If you want to modify the legislative power, if you want to modify any list in 7th schedule, 7th schedule modification requires 2 steps. One, special majority at the parliamentary level, and also simple majority in half of the states. So in 1976, this was done when 5 topics from the state list were sent to concurrent list. Okay, that is why state list had 66 topics. 5 were removed from there, it became 61. Later on, due to GST, 2 were removed further, it became 59. And concurrent list had only 47 topics. So 5 came there, it has now become 52. Are we clear? So it was because of this shift only. Now, also, representation of states in the parliament, schedule 4 and all, and also the number of MPs that you have in the parliament, it is based on which census right now? 1971 census. Number of MPs is based on 1971 census. Internal boundaries have been modified on 2001 census. So that 1971 census also came through 1976 Amendment Act, the 42nd one, very famous Amendment Act during emergency. And lastly, if you want to change the process of amendment, that also requires the same process. Changing the procedure under Article 368. Are you clear? This is the federal structure. We have a question from this last year. So please mug up this, don't forget. And we have had multiple questions on conditions of amendment. So amendment is an important topic. Should we proceed? What are the conditions? Look at the conditions. Very, very important to remember that such bills can be brought only in the parliament, any house, Lok Sabha or Rajya Sabha, but not in the states. Point 1. Number 2, this bill can be brought by any MP, minister or non-minister. So who is a non-minister? Private member. Private members are non-ministers. Any MP who is not a minister is called a private member. Are we clear? Can a private member be from BJP? Yes or no? Yes, of course. The only condition is they should not be a minister. Okay. So all remaining MPs are called private members. So such a bill can be brought by both non-minister and minister. Number 3, there is no such condition for prior permission of president, not required. Okay. Like Article 3, reorganization, it required the prior permission of president, or money bill requires prior permission of president. This does not need any such permission. Also, there is no concept of joint sitting. If one house passes the bill, other house does not, the bill is not passed. Simple. Both houses must pass the bill separately. So, no joint sitting. And the president must give his assent to the bill. It's mandatory. He can neither withhold his assent nor return the bill for reconsideration of the parliament. Clear? So for the president, there is no veto available. This was done through the 24th Amendment Act 1971. No veto power. President has to sign such constitutional amendment bills. Are you clear? No absolute, no pocket, no suspensive, nothing can be used. All okay? Any doubt? No? Now one last point to mention here is that there are some other places also where the same majority, that special majority is used. What special majority? 2/3 present and voting, more than 50% total strength. Where if you want to remove the judges of Supreme Court, judges of High Court, who is CEC? Chief Election Commissioner. If you want to remove this fellow also, same majority. If you want to remove the CAG, Comptroller and Auditor General, same majority. SEC, State Election Commissioner, same majority. All these people are removed in the same manner also, but same type of majority also. Are you clear? What is that? Special majority combination. Also, if you want to approve the national emergency, it requires the same majority. 2/3 present and voting and more than 50% total strength. Also, this Article 169, we'll discuss it later on, but if you want to create or abolish a council, there are 2 steps. Step 1 is that the assembly, within their own assembly, that proposal requires special majority. Are we clear? In the assembly. It is then sent to parliament, which requires a simple majority. But first step is special majority, same majority. And also, once we discuss panchayats, I'll explain the provision. Part 9 refers to panchayats. Panchayat provisions are not applicable in these three states, Nagaland, Meghalaya and Mizoram. But if you want to extend the Panchayat provisions, it requires the same special majority. Are you clear? State legislature has to pass it by a special majority. So the same majority is required in other places also. Please mug up this as well. Clear? Okay. So that's about it with respect to our amendment. Very simple. From this topic we have seen multiple questions asked in the exam. So also what we'll do is, every class that we begin, the first few minutes we'll devote to solving some PYQs. So we cannot solve right now because right now I just thought we'll just revise. Today you go home and revise, you'll have a test and all, that's also there. Apart from that, the PYQs that have come from those topics we'll discuss tomorrow. The very first 10-15 minutes we'll devote to discussing the PYQs only. Are you clear? All those that came in the exam from the topics we have covered today. This will be done every day. So we cover both these things, the topic as well as the PYQs. So that's it, amendment done. And last topic for today, very simple topic, basic structure. Basic structure, number one, some important points to understand, that it is not defined. Number two, it is also not mentioned in the Constitution. Excuse me. So this is a Supreme Court innovation. Supreme Court innovation. Which judgment? Keswanand Bharati, 1973, 24th of April 1973. This judgment came for the first time. So these are some examples of elements of basic structure. I would prefer that you go through these examples and mug up roughly, so that in case there is a question like that, then we can eliminate very easily. Okay, things like supremacy of the Constitution, secular character, federal character, judicial review. This word judicial review is not mentioned anywhere in the Constitution. Okay, you will not find this phrase anywhere. It has come from a Supreme Court judgment. Yes, very good. Minerva Mills, 1980, very famous judgment, where Supreme Court said that judicial review is a part of basic structure. Something not mentioned anywhere, they made it a basic structure also. That's Supreme Court's beauty. Who can question them? Or else, contempt of court problem. See, parliamentary system, part of basic structure. Rule of law, part of basic structure. Independence of judiciary, the very famous fourth judge's case, as it is called. When we had created the NJAC, then it was cancelled. It was cancelled. The 99th Amendment Act in the Supreme Court Advocates on Record Association case of 2015. That was the fourth judge's case, as it was called. It is there that the Supreme Court said that what? The independence of judiciary is a part of basic structure, and if you compromise with that, we'll have to cancel the amendment. So this is a part of basic structure. Okay, all these things are part of basic structure, but please understand, fundamental rights are not a part of basic structure. They can be amended. It is just that the essence of rights can't be amended. Rights per se in itself, they can be modified. We'll discuss that tomorrow, that rights can be amended. Okay, but the reason why we have rights, that can't be removed. Clear? So that's about it for basic structure. Nothing much to discuss here. This will cover our prelims part. Okay, done? Great. So go home, revise these notes, whatever you have written here, and that should be sufficient for the prelims exam. Tomorrow we'll discuss fundamental rights. So the entire 2 hours will be devoted to discussing rights only, because we have a lot of smaller topics there also to cover. So we'll firstly start our class with some questions that have come from these topics, and then we'll proceed to discussing fundamental rights. Okay, so this is your notes. Don't create new notes after this. Then I'll go home and write this in my own beautiful handwriting and highlight it with 5 kind of highlighters, design, etc. It wastes time. Rather, read this 5 times. Are you clear? Okay. So that's all for me. Jai Hind. Let's meet tomorrow. Any doubts? Doubts, issues, concerns? Doubt? No doubt. What is the next thing now? You'll have a test today or tomorrow? No idea. Okay, great then. Let me just confirm before you run away with full speed. Wait. Tomorrow hopefully we'll start at the right time. Yes, online people. Oh, sir, Lakshmikant book and these notes are sufficient. These notes are sufficient. Ignore Lakshmikant. If you already studied from Lakshmikant. So do we have some tests right now? Watch it. Okay. Test is some different time. So as far as Lakshmikant is concerned, again, you are senior aspirants now. You know all this. Why should I waste time in explaining to you all this? You are misguiding the upcoming aspirants now. You have reached that stage. Sorry, guiding the upcoming aspirants now. So my point is that you can simply, if you have already devoted your heart, mind and soul to Lakshmikant, you have underlined the entire book, etc., then revise from there. But largely these notes are sufficient for the exam. Nothing much would be required. But you can of course balance it because the FOMO factor is there. So because only for your FOMO factor you have to read Lakshmikant. Otherwise for exam it is not required. Clear? Okay. Sir, cases related to, not really. We have not seen, we are discussing prelims here, sorry, so not mains. So we don't need the cases for basic structure, including the Shankari Prasad or Sajjan Singh, not required, because you have not seen a single question like that in the exam. So we prepare based on the exam. We don't prepare based on what we feel will be asked. That's an important point. So we will prepare based on the syllabus and based on what has been asked so far. In the last 30 years, if something has not been asked, then it won't be asked. And if you are so unlucky, then what can I do? You will spoil my track record also. That when you sat for the exam, that question was asked for the first time in 40 years, then please let me know if your luck is like that. Right? I also need to know this fact. So not required, Vishwesh, don't worry. Any other doubts, queries, concerns? Sometimes less is more is also a good thing strategy to follow. Okay, let's meet tomorrow. Jai.